So let's start with today's lecture. Today's lecture is lecture number 13, which means that I will only see you once next week and then we are going to have the exams. I hope you have already been informed that the exams are not going to take place in this room, so you need to be careful. I repeat, the exams are not going to take place in this room, so you need to be careful. The exams are going to take place in room 30 of, is that building 4? It says 4 Kyo. So it's, okay, it's building 4, room 30. Is that enough for you? Or? Okay. Do you know where it is? Where the building is? No.
4教30室みたいですけど、多分みんな分かってると思います。奥の方です。一番奥の方。
Oh my god, okay. Okay. So which means that I have to walk carrying your exam. So please be careful. And also, so thank you Matthew. And also please be careful of the time. Your exams will last for 80 minutes, so we will start on 2:45 and finish at 4:05. Okay, it's an 80 minutes. Yes. Any questions regarding this part, this information? So, it seems that today I'm a bit tired. I need vacations because I was trying to show this to you and I was like, oh my god, something is wrong. And then I called, of course, our specialist, Masatake, and he came here and his answer was that the PC was not plugged in. So, so yeah, it's evidence that I need some vacation, but anyway, so let's start with a short revision. So, last week we were talking about the Product Liability Act, and I told you that this is very important for your exams too, so you need to be careful. We emphasize that, please be careful. The Civil Code is a general law, and the PL Act is a special law or a special act, which means that if there is a provision in the PL Act, we use that. If there is no provision in the PL Act, we move back to the Civil Code. So we need to use both of them. What's the big difference between the Civil Code and the Product Liability Act? Regarding product liability, it's very easy to answer. In the case of the Product Liability Act, it's sufficient if there is a defect, whereas in the case of the Civil Code, there needs to be also fault, which is many times difficult to prove. We are also saying that the Product Liability Act is extremely useful in cases where the consumer, the buyer, wants to pursue the responsibility of the manufacturer because there is no direct contract between the consumer and the manufacturer. So usually you would have to use Articles 709, etc., which have to do with torts. But again, you need to prove that there is fault on behalf of the manufacturer. So you see how important the Product Liability Act is. 3 requirements for liability. You need to remember that I received many questions regarding this slide. I'm not sure why, so let me repeat this. The Product Liability Act is very useful, but it cannot be used in all cases of product liability. According to Article 3, cases where the damage is restricted only to the product do not fall under the scope of this act. which means that, and please underline again if you have not done yet, please underline the words consequential damage, in Japanese, kakudai songai. So, what does this term mean? For example, I showed you the case of the canned salmon, and we were saying that if the canned salmon is defective, then there is no consequential damage. But if somebody ate it and was food poisoned, etc., then there is consequential damage. And we were also talking about the case of the TV set which caught fire, and I showed you a photo. So I received many questions regarding that photo. Students were asking me, so the wall behind the TV was burned. Is that consequential damage? The answer is of course yes, of course it is. So that's why I referred to an example where the TV set was put in the backyard where there is nothing. So nothing was destroyed except for the TV. Okay? Products. Please remember that only movables are included in the notion of product, which means that real estate, for example, houses, are not included. So if you buy a defective house, you cannot use this act. And please remember that we have two key words. The first is manufactured and the second is processed. So if a product is neither manufactured nor processed, it's not a product under this act. And I think you remember the example of mineral water, or the example of blood products, or the example of the sashimi that actually happened in Japan. So you need to have manufacturing or processing. Defect. 3 types. Chisaki told us about the warning defect in the maybe imaginary, we are not sure, case in the United States where the old lady put her cat in the etc. You remember this? And I also emphasize that it also has to do with importers. Although they are not manufacturing, they are included in the notion, so they also bear responsibility. And I told you that you need to be careful because it's a very profitable thing, doing imports, exports, etc. But if you are an importer, then you bear responsibility as a manufacturer under this act. We talked about exemptions, and if I remember correctly, Matthew gave us some ideas about the industry sectors which might be related to these exemptions. We are not sure, we don't have any proof, but yes, most probably. We also talked about the limitation of period, 2 limitations, 3 years and 10 years. And we talked about the scope of damages. You need to remember Article 6 of this Act, which says that if there is no provision in me, please have a look at the Civil Code. And actually, there is no provision regarding the scope of damages. So we have a look at the Civil Code, and it says that the damage which is compensated includes ordinary damage and special damage, but the latter is included only in cases where it was or could have been foreseen. Any questions regarding the PL Act? Anything you did not understand? Anything you would like me to repeat? Yes, please. Could you give the mic or could you use the mic?
I forgot to ask this last week, but how much processing do you need for this packaging? Like sometimes its processing can be very little, like putting label to very elaborate. Of course, the elaborate one is covered here, but how simple is it here?
That's an excellent question. So you need to check again. You need to check again Article 2, Paragraph 1. Calvin, could you read this article? Of the Product Liability Act. Could you please use the microphone?
The term product as used in this act shall mean movable, which is manufactured or processed.
So, if you read the act, you can see that it is not specified, which means that it depends on the judge's decision at the end. I think a very good example is the example of the sashimi I showed you last week. So you see that cutting a fish in small pieces, etc., and removing, etc., was considered to be processing. So it depends on the case. The criterion will be whether it is fair under certain circumstances to judge that that person who is doing what you said bears responsibility for the product or not. So that will be the final criteria. Here we come. Any other questions? Anything you would like me to repeat, to add, etc.? No? Okay, so let's move to today's material. So, as I told you, I'm in urgent need of vacations. Unfortunately, I'm not going to have vacations even after the lectures finish because anyway. So, but the good thing is okay. So. I need to deeply apologize to you because I've made a very big mistake in today's material. I apologize and I request for your understanding and also would like to kindly ask you to make some corrections. Today we are going to talk about false accusations. So the big mistake is that of course, when we talk about false accusations in Japan, we usually use the Ashikaga murder case. The large mistake I did, and which you should avoid when writing your reports, etc., is that I was doing copy-paste. But, no, I was doing copy-paste from my material, okay? Not from internet. But I was doing a wrong copy, so the paste was also wrong. The name of the person who was wrongly accused in this case is not Ashikaga, because Ashikaga is the name of the area. So, whenever you find the word Ashikaga in this slide, and the next slide, and the next slide, you need to replace it with Sugaya. So, you need to make, I think, 6 corrections, something like that. But don't worry, I will upload the correct slides on classes. But please, whenever you see the word Ashikaga, not in the title, but in the content, please replace it with Sugaya. So it's this, Sugaya, S-U-G-A-Y-A. I have corrected it here, but I realized it after preparing today's material, after printing it. And we need to be environment friendly, so I could not throw away 150 copies. So I deeply apologize, and I promise that next time I will do copy paste, I will be more careful. So today we are going to talk about false accusations. False accusations is something which exists in all countries, so it does not have to do only with Japan. But it seems that the Japanese criminal system has been criticized internationally for a reason we will see later. What does this case have to do with? It's a case which happened in 1990. Before you were born? Wow, I was 10 years old anyway. So it's something which happened before you were born. A 4-year-old girl went missing from a pachinko parlor. So what happened was that her father was playing pachinko, and she told him that she's going to play in the parking area. And then when he finished playing, he could not find her. The next day, she was found dead at a river nearby. This was not the first incident in this area. Actually, it was the third incident. So there were already 2 girls killed in this area in a similar way. So that's why the police actually reacted very fast. When the father went to the police station, they started looking for the girl, and they found her dead the next day. 1 year later, Mr. Sugaya, who was a bus driver for a kindergarten, if I'm not wrong, was asked to go voluntarily to the police station, which means that at this point he is not yet arrested. So you need to be careful. When somebody is asked to go voluntarily to the police station, it means that he or she can refuse. Okay? He or she is not arrested. Why was he asked to go to the police station? Because the police was investigating many issues, and they did a DNA test. And the results showed that his body fluid, which was found on some tissues he threw in his garbage, matched the body fluid's DNA, which was found on the girl. So he was voluntarily asked to go to the police station, and he confessed. So you have a perfect story. You have a DNA test which shows that the DNA matches, and you have a man who is a suspect. He goes to the police station voluntarily, and he confesses. Now, this is the newspaper presenting the news of his arrest, and you can see that it says that the DNA matched, etc. So, a trial began, and he was prosecuted for homicide, abandonment of corpse, and kidnapping for indecency. But from the 6th trial hearing, he started denying the crime and claiming innocence. In July 1993, the Utsunomiya District Court, which was in charge of this case, sentenced him with imprisonment with work for life. In 1996, the Tokyo High Court dismissed the appeal, and in July 2000, the Supreme Court dismissed the final appeal, which means that this decision became final. Why did this case draw so much attention? Because, as you can see at the bottom, it was the first Supreme Court decision admitting the competence of a DNA test. So actually, the history of DNA tests is not so long. In Japan, this was the first Supreme Court decision, 2000, admitting the competence of a DNA test. However, he continued claiming to be innocent, and in December 2009, the Tokyo High Court decided to perform a second DNA test, the result of which was that the DNAs do not match. So, in June 2000, it's not 9, it's 10, I think. oh, there's some mistake with the dates, I will check it later and upload the correct ones. He was released from prison and he was later pronounced innocent. So, I think you have two questions. The first is, why did the first DNA test show that his body fluid is the fluid which was found on the girl? And the second question, I think, would be, why did he confess if he did not commit the crime? So, these are the two basic issues we will treat today. This is a photo after the last court decision which pronounced him to be innocent. So he was released after 17 years in prison. And there are many cases like this in Japan and also abroad. So, before talking about the issue why, this is something we need to check again. Presumption of innocence. Maybe you know this, but it's something that the media and also we usually forget about. So if you watch the TV news or if you read the newspapers, you will see the face of a guy who has been arrested and he is a suspect or an accused about something, and the news usually treat him as if he has actually committed the crime, forgetting that nobody can be treated as a criminal until a guilty verdict is rendered, which means until the trial actually finishes. So, my question is, why do we have then to release in the news the name, the age of the person who has been arrested? For example, if I'm arrested for something, you will see my name, my age, my photo, but I'm not yet guilty. I will be guilty after the trial finishes. So my question is, why do they have to put my full name, my age, my photo, if I'm still presumed to be innocent? A second thing we usually forget, maybe because we watch too many movies, is that the public prosecutor needs to prove that the accused is guilty. What does that mean? It means that the accused is not obliged to prove that he is innocent. If you watch the movies, you have the police officer asking the suspect, so where were you on the night the murder happened? And the suspect is like, I was sleeping. Was there anyone with you? No. So you don't have any alibi. But actually, this has nothing to do with the legal provisions, because the legal provisions say, no, you, the public prosecutor, you need to prove that he is guilty. So even if he has no alibi, he is still presumed to be innocent. So let's read the first provision for today, Article 336 of the Code of Criminal Procedure. Who would like to read the provision? Yes, please. Could you pass the microphone? So, I'm sorry, I need to remember your name, but could you please repeat it?
My name is Masto.
Oh, and your family name is Kisada? Okay, thank you. Yes, could you please read the provision?
Article 336. When the case under public prosecution does not constitute a crime or has not been proven to be a crime, the court shall render a not guilty verdict in the judgment.
So, thank you. You can see that this provision does not directly provide about the presumption of innocence. Actually, there is no provision directly providing. But if you read the provision, it says does not constitute a crime, or, and maybe you should underline this part, has not been proven to be a crime. So, the public prosecutor needs to collect evidence and prove that that person is guilty. And I repeat, it's not the accused's obligation to prove that he is innocent. Yes, it's almost the same. Under Japanese law, you usually use burden of proof for civil procedure, but it's the same. Yes, it's the same notion. Now, something which is very strongly connected to the presumption of innocence. So, presumption of innocence means that if you in the future become judges, you also need to treat the accused as if he is innocent until the end of the procedure. Which means that we need to have some provisions or systems making sure that the judge will be as much as objective as he can, and that he or she will not be influenced by other factors. One of these systems is a principle called primacy of the indictment principle. In Japanese, it's called kisojo ippon shugi, and you cannot find it in any provision. Again, it's an academic word showing this idea. So, what does this idea have to do with? As you can see on the slide, the public prosecutor is the one who institutes a prosecution. He is the one who says, okay, let's take him to the court. And when doing so, he submits to the court only, and please underline only, the charging sheet. And he does not submit any other documents or evidence. So, even if you have a DNA test, even if you have any other evidence, you don't submit that as a public prosecutor. You only submit the charging sheet, which says what he is accused of doing, etc. Why is that so? In order to keep the judge not prejudiced. Of course, we live in a world where, of course, judges watch TV, they also use the internet. So as a judge, if you see the photo of this guy and the media saying that, oh, there is such evidence, etc., and people say that he's the one who did that, etc., you will be influenced, so you will be a bit prejudiced. But at least regarding the official procedure part, the judges are not influenced by such information. They just read the charging sheet when the procedure starts. So, this has to do also with the constitutional provision, Article 37. I would like to read it. So let's go to Yuki and then to Chisaki. Could you please pass the mic?
Article 37. Okay. Article 37. In all criminal cases, the accused shall enjoy the right to a speedy and public trial by an impartial tribunal.
Okay, thank you. So, if you have a look at this provision, it says by an impartial tribunal, which means, of course, by a judge who is not prejudiced. Now, if you check page 2 of the provisions I gave you today, you will find Article 256 of the Code of Criminal Procedure. This provision explains what the content of the charging sheet is. What's the charging sheet again? In Japanese, it's kisojo, and it's the paper that the public prosecutor submits to the court. It's the only document submitted by the public prosecutor. You can see that it contains the name of the accused and other matters necessary to specify the accused, the charged facts, and the charged offense. So only this information is included in the charging sheet. So the charging sheet does not say, for example, that, oh, actually this is the third time he is arrested by the police, for example, or any other additional information which might be relevant to the procedure, but not at this stage. So the judge only reads this information, and then you start the procedure and you start submitting additional evidence. The question is, what happens if the public prosecutor gives some additional information to the judge? Here is some additional information for you. We go to Article 338, Paragraph 4 of the Code of Criminal Procedure. So, Chisaki, could you please read the beginning of the article and then number 4?
The court shall, by a judgment, render a dismissal of protection when, for the procedure of the institution of prosecution is ineffective because of violation of the provisions.
So, according to this provision, if there was a violation of the provisions, including the provision which says that you submit the charging sheet, etc., the prosecution is dismissed, which means that the person, even if he actually is guilty, cannot be sentenced. Now, the next issue, before going into details, has to do with the request for retrial. In Japanese, saishin seikyu. Why? As we saw in this case, he was sentenced with imprisonment with for life, and the decision became final in 2000. But 9 years after, we have a second DNA test, which means that although the case was once finished, we start a new procedure for it. So the question is, how can we do that? We can do that by using the so-called request for retrial. We need to read Article 435. So please have a look at Article 435 of the Code of Criminal Procedure. It's a long article, so I'm not going to ask you to read it. It's on page 3 of today's provisions. And it starts like this. A request for a retrial may be filed against a final and binding judgment of guilt when filed in the interest. So please underline, when filed in the interests of the person who has been found guilty, and when. So the first important element, the part which you underline, says that a request for retrial can be only filed in the interests of the person who has been found guilty. When we have 1, 2, 3, 4, 5, 6, 7 cases when such a request can be filed. For example, if you see number 1, it says that the evidence is false or has been altered. Number 2 says that a testimony was false, etc. So, only in these cases, in these 7 cases, and only in the interest of the person who has been found guilty, you can file a request for retrial, which means that, as the name shows, we have a new trial regarding the same case. So, the next question is, okay, let's say that, for example, in this case, his punishment was imprisonment with work for life. What if it was a death penalty? So, the answer is, where there is a ground for a request for retrial, please underline, a ruling to commence retrial is rendered. So you have a court decision which says we will start retrial. And you can see that we can also have an additional ruling to suspend execution. But please put a circle around may. So this is not compulsory, okay? The judge may render an additional ruling to suspend execution. Of course, if it's a death penalty, yes, this additional ruling will be rendered. So, to summarize, request for retrial, you have the requirements in Article 435. If it's admitted, then we have a ruling to commence retrial, and we might have an additional ruling to suspend the execution, which is always the case if it's a death penalty, otherwise there is no meaning for the retrial. Now, as I have told you during an older lecture, in Japan the death penalty is not automatically executed. As you might remember, the person who has been sentenced with a death penalty is kept in prison, and he waits until the Minister of Justice decides that his death penalty will be executed. So, the question is, let's say that we have a request for retrial, which has not been yet admitted. So there has been a request, and the judge is thinking whether to allow for a retrial or not. Can the death penalty be executed during that period? The answer is, legally, from a legal point of view, which means according to the provisions, the answer is yes, there is no problem. Because the request for retrial has not been yet admitted. It's just a request. But usually, the minister does not execute the death penalty until the court decides whether to admit the request or not. It's only a usually, it's something like a custom. In the past, there have been cases, at least one case, where a person's death penalty was executed after he made a request for retrial. But it was not the first request, it was his 7th, I think, or 8th request. Which means that 6 requests have been dismissed until then. So he was doing that, why? In order to prolong his life. So, in Japanese criminal practice, you will find many lawyers who submit a request for retrial just in order to avoid having the death penalty being executed. You make a request for retrial, you know that usually the Minister of Justice will not execute the death penalty. Your request is dismissed, so then again you file another request for retrial, because you know that during that period the Minister of Justice will not execute, etc., etc. So you can see the reason why it's only a custom. If you have many repeated requests for retrial, then it might be okay for the Minister of Justice to execute the death penalty. Okay? Any questions up to this point? Yes, Matthew, could you please pass the microphone?
Just curious about after the death penalty, is it possible to get a pardon if they're proved to be innocent?
Yes, in that case, the person will be pronounced innocent after his death.
And is there also monetary compensation paid out?
That's a good question, and we're going to talk about that later. Excellent question. Any other questions? So, we move to the most important part of today's lecture, confession. Actually, this was the reason why Japan was internationally accused of having a very medieval system. Okay? That was the actual word used by a foreign diplomatic way. So, in the past, not only in Japan, but also in other countries, confession was regarded as being the king or queen of evidences. So it depends on whether you would prefer confession to be a king or a queen. You can use either of these words. But nowadays, confession is not anymore the king or queen of evidences. We will see the reason why after a short break of 5 minutes. If you have any questions, feel free to ask.
パン切ってんだ。いや、ここからコンパスある。じゃあ。縛りです。
No, you never come. Dude, my lunch really It was other people in the car. My friend is One time I actually also did that, and like it was confusing. At first, it was like I just believed like medical school, and I didn't know that.
So, let's talk about the former king or queen of evidences, the confession. I received an excellent question. So, I go back home tonight. I open my Facebook account and I write, 2 years ago I killed a person. LOL. And the question was, is that a confession or not? The answer is it's not a confession. Why? Because a confession needs to be made in front of the police officers who are doing the investigation or during the court. So the next question is, yes, but can the public prosecutor not use that information? The answer is, of course, he can use it. He can use it as evidence for the investigation, okay? But it's not a confession. Further, maybe you know it's the same in all countries. Even if I go to the police station and I tell them, I'm the guy who committed this crime, which is still unsolved, it does not mean that I will be pronounced guilty. They will do an investigation and they might tell me to go back home because I'm lying, okay? Because in the cases of criminal procedures, we look for the truth, which is different from the civil procedures. If you take my lecture during the next semester, you will see that in civil procedures, if I admit in the court that, let's say that I'm married and I had an affair, or at least my wife says that I had an affair, which is wrong. But if I tell during the court procedure that, yes, okay, I had an affair, this is treated as if it's a fact. Okay, this is a difference between the civil and criminal procedure. Now, as I told you, nowadays, confession is no more the king or queen of evidence because we need to have some supporting evidence. We have a provision in the Constitution, and we have also a provision in the Code of Criminal Procedure according to the provision of the Constitution. Who would like to read these two provisions? Okay, answer please.
Article 38.
Yes, let's start with the Constitution provision, Article 38, Paragraph 3, and then move to the Code of Criminal Procedure provision.
Okay. The other article?
I think Paragraph 2 only, or 3 and 2 respectively is enough.
No person shall be compelled to testify against himself. Confession made under compulsion, torture, or threat, or after purge, arrest, or detention shall not be admitted in evidence. No person shall be convicted or punished in cases where the only proof against him is his own confession.
Thank you. So let's start with this provision first. You can see that it's a provision in the Japanese Constitution which has to do with confession. And in paragraph 3 it says that no person shall be convicted or punished in cases where the only proof against him is his own confession. Okay? And next, let's go to the Code of Criminal Procedure.
The accused shall not be convicted when the confession, whether it was made in open court or not, is the only piece of incriminating evidence.
Thank you. So, according to the provision in the Constitution, this provision repeats the same content and says that in paragraph 2, if confession is the only piece of incriminating evidence, then the accused cannot be convicted. This means that we need supporting evidence. Why is that so? Because in the past, before these provisions were established, confession was regarded as the king or queen of evidence, which means that police investigation focused on obtaining confession from the suspect. So, you can also see that in movies. I'm not sure if you have watched this movie. Oh, yes, it has to do with France. Yes, of course you have watched it. So, yes, I think the story starts in Paris, if I'm not wrong.
Paris and then in Grasse in the summer.
Yes, it's an excellent movie. You should watch it. I have also read the book. It was also excellent. It's a case, so the Japanese letters are quite small, but it says perfume, ある人殺しの物語. Ooh. So, and here you have the accused, who is actually the person who committed all these killings, but he is still tortured in order to obtain his confession, because of course, when was this story, Enzo? Do you remember?
Yes, if I remember well, the 18th century. It was in the period of Enlightenment.
Okay, which means
it's 18th century, around let's say 1750.
Wow. Okay.
I think.
Yes.
Possibly because Grasse at that time was like the capital of perfume and sort of representation of beauty, of like liberty, France and so on.
Oh, that's interesting. Thank you. So, according to the information by Enzo, this was in the 18th century, which means that you can, as you can easily guess, investigation was not so scientific. Okay? It was focused on obtaining the confession of the person. Here is also another scene from the movie. You should watch it. It's really, really interesting. So, the same thing was happening in Japan. If you Google a bit, you will find the story of a very famous police officer in Japan who was accused of obtaining confessions by accused persons using illegal practices, etc. And so, nowadays, we have these two provisions, which means that confession is not enough. You also need to have some supporting evidence. Now, we also have some additional provisions. Enzo has already read Article 38, paragraph 2 of the Constitution, which says confession made under compulsion, torture, or threat, or after prolonged arrest or detention shall not be admitted in evidence. And we also have paragraph 1 of Article 319, which repeats the same content according to the Constitution, to the Japanese Constitution. So, if you only have a look at these provisions, you would say that, oh, so nowadays confession is not so important. If it's the only evidence, you cannot pronounce somebody guilty, and you cannot obtain a confession by using illegal means. However, in Japan, there are some small issues. Also, according to the international procedure about which I will talk to you later, in Japan, police investigation is centered on the suspect's examination. I have not been yet examined by the police, so I cannot talk to you based on my experience. If you have any personal experience, maybe you could share it, but I don't think it's so easy for you to do so. So based on writings, etc., in Japan, if you are arrested or if you are under police investigation, the police officers tell you, so you did it. You did it. And they wait until you say yes or something like that. Now, number 2 is really important also for your personal safety in Japan. What's the issue? 2 issues. Once you confess, it is really difficult to convince the judge during the procedure, the court procedure, that your confession was not voluntary. So it is really difficult for you to use these provisions. Why is that? During the investigation, if you confess, the police officer will create some records of your confession. Please be careful. You are not allowed to write on your own your confession. They will write it for you, show it to you, and ask you, so is this the content of what you said? And if you say yes, they ask you to sign. And if you sign, usually it's the end, because it means that you have checked the content, you have found it to be true, and you have signed. So, you will find many foreign people accused in Japan. I know of some cases where this has happened, who denied to sign, which might be better, because then you can say during the court procedure that, no, this is not what I said, that's why I did not sign it. So this is the first issue. Second issue, however, if you go to watch a Japanese criminal court procedure, you will usually see the judge saying at the end, and the accused has not regretted committing the crime. That's why his punishment will be more severe. What does regretting mean? Well, it also includes confessing. So if you say, yes, I'm the one who committed the crime and I'm sorry for that, your punishment becomes less severe. But, so here we have something, we have an imbalance. On the one hand, if you have not committed the crime, of course you will say, no, I did not do it. But on the other, if you are found to be guilty, and if you are still refusing to confess, then this will be used against you, because it's an evidence that you have not regretted committing the crime. So, that's why if you watch Japanese TV shows with lawyers, some lawyers say, it's better for you to say, yes, I did it, and pay some money, because you will show that you have regretted what you have not done, but they think that you have done it. So, but you have not done it, but you need to regret it, which is okay anyway. So, in Japan, why do we have so many false confessions? As you saw, in this case, he confessed, although he was not the one who committed the crime, according to the second DNA test. So, according to the writings, a major reason why people confess during investigations is that in Japan, you're not allowed to have your lawyer with you during the investigation. Which means that during the investigation, in the room, it's the suspect and the police officers, or the public prosecutor. Where is the lawyer? He is waiting outside. He can meet you. So he can meet you after the investigation, before the investigation, but not during the investigation. So it's not like in the movies where the police officer, but I think it's the same in the States, I'm not aware of it anyway. But you don't have the lawyer with you. He cannot say, oh no, that question, police officer, you're not allowed to ask that, etc. You can have your lawyer with you. Could you use the microphone?
I can't speak for civil law, but I know that in all common law countries, a defense lawyer is required to be present, particularly in the case of minors. It must be that they cannot have the suspect alone with the police during interrogation.
Okay, thank you very much. So, in Japan, you cannot have your lawyer with you. And it's really funny because if you Google, you can find the website of a law office which was saying, so we cannot be with you during your investigation, but you can use us for giving them less time to investigate you. What does that mean? We can send you many lawyers in order to meet you before the investigation. So if you have 3 meetings during the day, 6 hours, then you have 6 hours less investigation, which is a bit funny because you need to pay them for the time, okay? So it's not for free anyway. But this is the situation in Japan. So many doctors, many people who are professionals in psychiatry, etc., say that when you are alone in the investigation room with the police officers or the public prosecutor, you have a large future disadvantage, which is the danger of being found guilty in the future, and a small current disadvantage, which is confessing, saying, yes, I did it, so please let me alone. And according to professionals, you usually choose the second. You say, okay, it's a small disadvantage. I will just say I did it so that they will leave me alone and I can have some rest. And you forget about the large future disadvantage. However, when I do this lecture, it looks as if the police officers and the public prosecutors are the bad guys and the suspects are the good guys. But it's the other way around usually. So we should think about this from many viewpoints. If you think it from the viewpoint of the police officers, having the lawyer present in investigations means that you will get most probably nothing from the investigation. The lawyer will interrupt you, he will say, don't ask this question, don't answer, etc. So it's very difficult for you to obtain information. And from the viewpoint of the other citizens, we cannot be sure which is better. Okay? Of course, we would feel more safe if we could have our lawyer with us. But I have not been yet accused of doing something wrong, and the probabilities of being falsely accused are a bit low in general. So I'm not saying which is correct, but I need you to think of both sides. Okay? It's not only this side. Anyway, in May 2016, there was an amendment of the Criminal Procedure Act in Japan, and they provided that regarding some heavy crimes, some severe crimes, the procedure will be recorded, which means that the suspect or the accused, the suspect, okay, will not have his lawyer with him, but the interrogation will be recorded. So most probably the police officer and the public prosecutor will not use compulsion, torture, threats, etc. Because the procedure will be recorded and we will be able to use the recordings during the procedure. Now, there is also another reason why, according to criminal law professionals, in Japan we have many false confessions. This is the procedure flow after the arrest of a suspect. So, we will talk about details during the second semester, if you choose this lecture. I think that it might be difficult for Faculty of Law students to choose my lecture because you have some other lecture on the same day and time. I'm not sure, but you need to check anyway. So please call your friends to this lecture because most probably we will have 0 Faculty of Law students. Now we have 40 something, which means 190 minus 40 something, 150, which means 80 maybe students present in the lecture. So please invite your friends to attend this lecture. Okay, we'll have a large reduction in the number of students anyway. So, what's the procedure flow after the arrest of a suspect? Please underline police detention room. This is a room in the police stations. So, it's not a jail. It's a place where you can be kept up to 72 hours after your arrest. So, police can use up to 72 hours, which means 3 days, in order to decide whether they should bring you in front of the public prosecutor, etc. So, I'm not sure if it felt for you long or short. Maybe for students it's short, but for us, we have to go to our workplace. If I'm arrested on Monday, although I have done nothing, it means that I will lose Monday, Tuesday, Wednesday, so I will lose the professors' meetings, I will miss many meetings, etc. Which means that maybe it's better for me to say, yes, I did it, so here's your 1 million again, see you again, bye. Not hoping not to see you again, bye, and go back to my workplace. So, 3 days are already big pressure on a person who is working in a company. And you can still see that it's still continuing. After the 3 days, if you are brought in front of the public prosecutor, etc., then it's up to 10 days, which may be extended for another 10 days. So it's 23 days until prosecution. Please be careful. This means that during this stage, you're still a suspect. You're not an accused. You are a suspect, which means that maybe they will decide to release you after 23 days. So, you can see that this is a big pressure. Yes, of course.
I think by prosecution you mean charge,
Yes,
as in without charge.
yes,
Okay.
yes. Because in Japan you need to have a prosecution by the public prosecutor in order to start the official.
We call it charge.
Yes, it's the same. Yes, exactly. So, in this case, even if you are innocent, this is just an investigation procedure, 23 days, and maybe they will tell you, oh, so you did nothing wrong, you can go back home. But you can understand how big the pressure, how strong the pressure is. So, they say that this might be another reason why people in Japan sometimes choose to confess. And I agree, especially in cases of the of offenses having to do with touching a woman's body in a train, etc., which are against some local ordinances. There, the penalty is usually small, etc. So it might be better for a man to say, yes, I did it. So, but according to some friends of mine who are lawyers, you usually have to pay 1 million yen to the alleged victim for her suffering. So that's why in Japan, media have been reporting that some women, especially some young women, high school students, were doing this as a part-time job. They were just standing around the man. They were from different schools, high schools. So one would say, oh, he touched me, etc. And the others would say, yes, we saw him, he did it. And the police officer would ask them, so which school do you come from? And he would see that they come from 3 or 4 different schools, which means that they are not friends, which means that your remarks are objective, which means that you did it, so etc. And you start with this, etc. So, because we also have to talk a bit about the Japanese culture. It's not a culture, but it's something which has happened actually in Japan, so you need to know it. So, finally, we arrived to the part which has to do with the United Nations. In 2013, the Committee Against Torture examined Japan's report on adhering to the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment. This became quite famous in Japan. Why? Because a diplomat of an African country told the Japanese delegate that your system in Japan depends on coerced confessions, and it reminds me of the medieval ages, etc. And then the Japanese representative said, no, Japan is a pioneer in the field of human rights. And the other representatives laughed, and he got a bit angry, and his behavior was not so diplomatic as it should, and it became an issue, and it was also broadcasted, etc. Now, okay, so my idea is that you, as university professors, as university students or future professors, you should think of both sides. So it reminds me of the whale hunting case. Let me give you my idea. I will not tell you which position I'm taking, okay? But my idea is the following. So we have some people who say, no, Japan, you should stop hunting whales. Why is that? Because, and they give some reasons. So other people say, so why is it okay to kill pigs and cows for eating them? And they will tell you, well, whales and pigs and cows are different, but why are they different? They're all alive, so we're talking about lives. So it's like the human lives which are not so equal, although they're supposed to be equal. People dying in Africa, nobody cares, but if some people die in a certain country, which is famous, we all care, and we change our Facebook photos, etc. So, here, I think that we can have two ways of thinking. The first is, yes, in Japan there is an issue regarding the investigation system because you cannot have your lawyer, etc. The other side is that, yes, but this does not mean that Japan is not a pioneer, is not a country which respects human rights. So, further, I'm not sure if the country, I will not give you the name, the African country from which the person comes actually respects human rights. So it's a bit complicated. It's not so easy as it seems to be. And I would suggest that you in the future, and also now, try to see things from many viewpoints, because as I told you, for example, I feel safe in Japan, but I don't feel safe in my country, in Greece. Why is that? Because there was an incident in Greece. It was really funny. Some people broke into my father's company, which is a famous German company, and they called the police. And the police car arrived, and they called my father and asked him, so are they still inside the building? He was, no, they left. So they were like, okay, so we're going inside then. Which means that if they were still inside, they would wait for them to leave first, because they care about their safety, etc. So it depends on which part you choose for the comparison, etc. Okay? Now, but anyway, okay, let me not forget to summarize this. But anyway, officially, Japan was a bit accused in this official, during this official meeting, of being a country which reminds of a medieval country where human rights are not so important, etc. Now, regarding the DNA test, maybe you were surprised because during the first DNA test, the findings were that his body fluids DNA and the body fluid DNA which was found on the girl's underwear matched, but during the second they did not. Well, DNA tests are not perfect, and you need to know that. There is a small percentage of wrong results, which was a lot larger 20 years ago, and a lot smaller now, but it still exists. So, it does not mean that DNA tests are always correct. There is a very small percentage of mistake. So that's why it is better always to have additional evidence. And there are also some mistakes during the DNA test procedure. There was this famous case of the United States football player Yes, I will not mention his name. So he was also, so during his procedure, DNA tests were also used, and his lawyers, he had very good lawyers, said that the police officers put the blood samples from different persons inside the same car in summer, which means that blood also it's hot, which means that yes.
Blood, in some situations, when it's heated, can lose its phenotypes. So A blood, B blood, and AB can become O in hot situations.
Exactly. So they said that this is what happened, which means that maybe the results are correct, but there was a mistake during the procedure before having the results.
Just additional information, they were in fact quoting a book by an author called John Mortimer, who wrote a law series, the Rumpole books. And they also quoted one of his most famous lines, which is, "This is a case of premature adjudication," i.e. already decided.
Thank you for the additional information. So, you need to keep in mind that, for example, there was a famous case, I'm not sure if you know about this case, in the United States, where a person was accused for rape because the DNA of some hair found on the woman's body. Yes, but actually that hair belonged to an officer who was carrying the body, and it fell on the woman's body while he was carrying, etc. So you can see that many things can happen. So it does not mean that, oh, we have the DNA results, you're guilty. Okay? We need to be really careful. And of course, there is a necessity to preserve the material used for the DNA test, especially in severe cases. For example, if it's a death penalty and there is a request for a trial, it will be tragic if the material used was thrown away. So we need to preserve it for all cases. And finally, so this has to do with Matthew's question. Let's say that somebody has been imprisoned. There has been a request for a trial, and he has been found innocent. The question is, what happens with the years lost? Who would like to read Article 40 of the Japanese Constitution? You decide. Oh, it's Maho.
Any person, in case he is acquitted after he has been arrested or detained, may sue the state for redress as provided by law.
Thank you. And we have two pieces of legislation regarding this. The first is the regulations for suspects compensation. Please underline suspect. Until there is a public prosecution, you are only a suspect. In Japanese, higisha. So, if the procedure ends there, before prosecution, and you have been kept somewhere for some days, you can ask for compensation according to these regulations. If you are an accused, which means that public prosecution has been initiated, and then you have been found to be innocent, you can use the criminal compensation law. How much? Money. So, of course, according to my favorite song, Price Tags, it's not about money anyway. Okay, but okay, so money is important, forget about that. So how much? According to the criminal compensation law, it is 1,000 yen to 12,500 yen per day, depending on the circumstances. I'm not sure if you find it to be enough or not. And please be careful. If you actually look, if you Google this act and you look its content, In cases of a death penalty, the maximum is 30 million. So I'm not sure if this is enough again or not, plus any other additional damage that has occurred. Now, going back to Matthew's question, there is also the State Redress Act. What's this? It's when you want to ask for additional compensation because the arrest or the prosecution was illegal or significantly unfair. For example, the only evidence they had was your confession, but they still initiated the prosecution, etc. So, in this case, you can ask for compensation against the Japanese government, which is a separate procedure. Okay, you need to prove, etc., etc. So it's not automatic like the other two pieces of it. Any questions regarding today's lecture? So, next week will be our last lecture and we will talk about some issues like abortion, etc. in Japan. And I will show you again last year's exams questions. If you have any questions, you can ask me after the lecture, you can send me emails, or you can come to my office. See you next week. Thank you very much.